Today, we're going to talk about the foreclosure process. As you know, our company has never lost a house to foreclosure. So I'm going to give you the secrets to saving your house from foreclosure. Now, I've been around for 25 years in this business, so you can Google me and see me all over the place. We have a number of celebrity clients. You can go into YouTube and see some of the testimonial videos. Let me tell you something that I found. Everything in life is mathematics. I love mathematics because it's an exact science. You know, mathematics relies on logical proof and deduction. So using mathematics, it deals with quantifiable concepts and provides absolute results when applied correctly. And that is the secret recipe that I want to teach you today. So once you have the quantifiable concept, all you have to do is apply it correctly. So today we're going to start with this quantifiable concept that it's impossible to lose your home to foreclosure in America. Now, I know that sounds weird and crazy and maybe kind of scary because millions of people lose their home every year to foreclosure. So how can this be? So that's what we're going to talk about today. Let's start by understanding the basic types of foreclosure. The two primary are judicial foreclosure and non-judicial foreclosure. Everything else falls under the category of other foreclosures. So judicial foreclosure means that the creditor has to take you to court in order to foreclose on your house. Non-judicial foreclosure means that they don't have to do that. So if you're trying to save your house, there's two completely different strategies depending on what state you live in. So the first thing you want to figure out if you're in a judicial or non-judicial foreclosure state. Some other types of foreclosures, reverse mortgage foreclosures. Now, you don't see a lot of people signing up for reverse mortgages anymore, but at one time during the 80s and 90s, you'd see guys like Tom Selleck really pushing this strategy on a lot of people, which turned out to be not very consumer friendly. And now all of these companies are foreclosing on people's property. Zombie mortgage foreclosures. So a lot of people had 80-20 mortgages. So 80% was with one lender, 20% with the other lender. During the foreclosure process, the other creditors may have dropped off or disappeared. Now these guys are coming back through debt collectors and they're actually foreclosing on your properties. Or if you've gotten your house paid off, these guys are resurfacing, trying to steal your homes. Homeowner association foreclosure. I mean, it's hard to imagine, but a homeowner association can foreclose and take your house. So we want to learn how to deal with all of these types of foreclosure. Now, it's important to understand this, and this is where most people fall down. Foreclosure is part of a system. If you Google this article by Time Magazine, the article says the top 1% of Americans have taken 50 trillion from the bottom 90% just in the last 20 years. In 20 years, they took 50 trillion. That's 2.5 a year. So currently, home prices have skyrocketed in the last couple of years. And currently, 94% of homeowners have mortgages with some equity built in. 94%. So if you're losing your house to foreclosure, that means you're losing equity. That is a small fortune. And even worse than that, in the fourth quarter of last year, nearly half of those homes were equity rich. That means you owe less than half of what the house is worth. That is scary in a foreclosure rich environment. So that is the motivation. This is a way to transition wealth out of certain communities, simply steal all of their real estate. And I want you to Google this and see this because this is very upsetting to me. It says that currently only 5% of homes are owned by banks. But by 2030, they're forecasting that 40% of all family homes will be owned by the bank. And at current rates, by 2040, banks will own more homes than individuals for the first time in U.S. history. That's how serious this foreclosure problem is. First problem is understanding how to stop a foreclosure. I told you that it was impossible to lose your home to foreclosure. So why, if that's the case, why are so many people losing their home to foreclosure? Well, it gets down to the methodology. So to see why there's such a problem, I went on to Google, which is everyone's standard source for information, and I Googled this: how to avoid foreclosure. I want you guys to try this for yourself. So Google gave me a concerted list of ways to stop foreclosure, and they have thousands of sources for this. So it's what you call a preponderance of evidence. So with 1,000 of sources or 100,000 sources telling you the same thing, you are going to believe it, right? So let's take a look at the top 10 choices that they gave you. So the first thing they said to do was refinance your house. What is the probability of that happening? If you're in foreclosure, that means your credit is destroyed, and even worse, your mortgage payment history is terrible. The last thing you will qualify is to refinance your home. So clearly, that strategy is fraught with danger. Next, they said, hey, mortgage acceleration. Again, if I'm having problems paying my mortgage, how can I accelerate the mortgage? How can I pay extra? Round up your payments. They said double your pay. Man, get out of here. All of these crappy strategies. So they did mention one thing that there's a lot of confusion about, irrevocable trust, putting your house in a trust. Now, there's a lot of advantages to putting your home in a trust. As a foreclosure defense, in general, it is not a good strategy to put your house into a trust. Primarily because by the time you decide to do it, if you're already in foreclosure, they will pierce that immediately in court of law. So your creditor will automatically, the bank is going to tell the judge, they're just using it as a way to stop paying us our money. So that is not going to work because it's too clear to see the strategy there. So the only strategy you should be using in advance of a foreclosure is called self-liquidation. So you bought your house, you've made payments on it for 5 to 10 years. In America, the longest you should pay on a house is 5 to 10 years. And I'm not talking about accelerated mortgages or doubling your payments, rounding up, any of that crap. I'm saying making your normal payments on a 30-year mortgage, the longest you should pay for that mortgage is 5 to 10 years. After 5 to 10 years of payment, you're in a situation that 94% of Americans face right now. And that means that you have equity in your property, or you're equity rich, like 50% of Americans. Now, what you should do, of course, you have good credit, you have equity, you refinance and take the cash out of your property. Right now, everybody has a ton of cash in their property. You don't own a home right now. You own a home sitting on top of a pile of money. The only question is, are you sharp enough to pull the cash out before it disappears? Because eventually the housing market bubble will bust and all your equity will be lost. So the first step is to refinance and cash out all of your equity. Now you take that equity, at least half of it, and you put it in a high yield brokerage account. So your brokerage account is like a bank account. And if you don't know about them or you have questions about them, please ask me. But the brokerage account is where rich people keep their money. Poor people keep their money in a bank. Rich people keep their money into a brokerage account. So the brokerage account is just like a regular checking or savings account, only it is insured up to 10 million. It has a lot more flexibility, and it pays a heck of a lot more interest. So you put the money, the half of your equity, into this high yield brokerage account. You put it on auto bill pay. So now the brokerage account is paying your mortgage. None of my clients pay their mortgage. Their brokerage account pays their mortgage. Even for investment properties, they don't allow their tenants to pay their mortgage. They allow the brokerage account to pay their mortgage. Now, after you do this, your brokerage account will typically pay your mortgage for another 5 to 10 years. So the question is always, okay, Dr. Grayson, what do I do after 5 or 10 years and the payments run out? Well, after 5 to 10 years, you can simply refinance again and repopulate the brokerage account for another 5 to 10 years, and you can do that indefinitely. Now, one of the key things to doing that is making sure you have credit life insurance. Please write that down. On every mortgage, make sure you have credit life insurance. Credit life insurance means that in the event that you die, your mortgage is paid to zero. In the event you die, your mortgage is paid to zero. So you should not be in the business of paying off your mortgage. That is flawed logic. Your insurance company's job is to pay off your mortgage. Your job is to live in your house for free. So once you do it with your own personal property and see how easy it is to live in a house for free, then the idea is to buy multiple properties and do the same thing. You know, one of the issues I have sometimes with my relatives, that, because I have properties all over the country, right? So they'll ask me, hey, I'm going to be in Miami. Can I use your house there for a couple weeks? No. Get your own. If you know me, you should have 800 credit score and you should have your own free houses. Don't ask to live in my free house. I might decide to go to Miami next week. Let me put you in your own free house. That is the strategy. So it's called payment-free real estate investment. Now, most people understand that real estate investment is good, but the way that they teach you as the average consumer to do it is fraught with danger, and a lot of you lose everything. You end up losing your real estate investment property. Do you know it's almost impossible to do that, but unless you do it the wrong way? In a payment-free real estate investment portfolio, it is impossible to lose your house to foreclosure, to lose your investment property. So we want to make sure you are always using the self-liquidation model. One of my guys called me and he was going crazy because he started using this model and he found this property, which they had listed recently, but he found it too late. Somebody beat him to it. I want you guys to Google this. This 16-story building is at 995 Market Street. It's in San Francisco. It just sold for $6.5 million. Do you see what the value of that property is? It's valued at $60 million. It's valued at $60 million. Can you imagine? $60 million. So as soon as they buy the property, what is the first thing that they should do? Cash out refi. You cash out refi, you get 40 million, 30 million. It really doesn't matter. You take half of it, put it in the brokerage account. The other half goes into your traditional saving, but half of it goes in the brokerage account. It pays to remodel and to pay the mortgage off. Can't be any simpler than that. At that level, you can afford to buy real estate. Your entire life should be dedicated. When I die, I told my family I should own a minimum of $100 million in real estate. You should be the same way. That should be your minimum goal, to own $100 million worth of real estate that you don't pay for. If you need help with that process, we will help you every step of the way. So let's talk about the foreclosure process. It's important that you understand it in order to be able to stop it. So I pulled the New York State foreclosure process for residential properties. It serves as a good guideline for the foreclosure process. So you miss your mortgage payments. Typically, it takes about 12 missed payments. Then the creditor or the bank goes into a 90-day, they send you a 90-day foreclosure notice. After that, they go into a foreclosure lawsuit. As soon as the lawsuit is started, you have to file an answer. That is a legal term. An answer is a formal document. So you have to file the answer. After you file the answer, the court will assign settlement conference. In settlement conference, the bank should be offering you some type of loan modification. The problem is most lawyers are not adept at loan modification, and so they fall down at this process. Most people apply for loan mod, don't get it. I would say probably 90% because they don't understand the mathematics, excuse me, of the foreclosure and loan modification process. However, if you're like 90% of individuals, you don't survive the settlement process, and then you should go right into what's called motion practice. So motion practice means you do discovery. Now, discovery is the secret sauce for foreclosure process. Now, I told you earlier that we have never lost a house to foreclosure. But understand this, if we start the action, we have never been to trial on a single foreclosure case. It has never happened. We always win in discovery. You know, it's hard for attorneys to think like that. Even the attorneys that work for us, you know, I have to beat them up, and it takes years of them working with us to see how that works. Most attorneys are geared to try to win in motion practice, or if they're very good at trial litigation, that's what they're focused on. What they don't understand in debt litigation, it's always won in discovery. So if you craft your discovery well enough, it will not go any further than that. So once we apply for discovery, the creditor invariably always runs from the case. They always settle or send you pre-approved loan modification. That is the way that we win. We don't go to trial and send in attorneys and beat up. No way. Even if we did, now again, it has never happened in 25 years. But if we did, I don't see how we can lose, because keep this in mind. Every juror and there's jurors, they're all your peers. The jurors are on your side. So I don't think it's going to be possible for you to lose in a jury trial. But discovery, and again, if you have questions on that, discovery is how you win. If you don't, then you could fall out at any of these stages and you're going to auction. For a non-judicial foreclosure, it's more straightforward. You miss the payments, you get as a notice of default, then it goes to trustee sale and auction. You're out of there in a very short period of time. Now, it's important that you understand the process so that you understand, and you have to be more proactive. You know, we go behind a lot of law firms that have lost homes to foreclosure, and always the client never knows what stage they're in. The reason I gave you the system is so you can ask them, what stage are you in? So that you know what is the proper protocol. So if you start with the foreclosure notice and you answer, this is one of our secret recipes. Please write this down. When you answer a foreclosure, you answer with a cross motion for damages. So now I am going to make it painful for you to lose. You can't get loan modification and you can't win because you are not walking with a baseball bat. When we go to court, or when our clients go to court, we equip them with baseball bats. So you're going to beat the bank in the head with this bat. And one of those baseball bats is called cross motion for damages. So because you know that this bank is foreclosing on you and they should not be foreclosing, they are creating emotional damages. They're destroying your credit. There's a whole list of issues. All of these things are damages for you. So whenever you answer a foreclosure complaint, you should also, in your answer, provide a cross motion for damages in excess of $1 million. This will force the courts to litigate this issue because now not only do they have to address the foreclosure complaint, but now they also have to address your cross complaint. That's how you get them. You do a cross motion and cross complaint. That's how you get them. After that, you want to make sure that your attorney is replying in opposition to everything that the other lawyers they supply, and then you appeal that decision. Now, at any stage in the game, if you feel like you've lost, or if your attorney say you lost, the right way to step in is with a motion to vacate or an order to show cause. So even though you've lost the foreclosure or you've lost the a judgment of foreclosure, you could step in with a motion to vacate or show cause and overturn those immediately. You can get back in the game. Now, if you've tried those and you've lost, no problem. You can file a wrongful foreclosure action or quiet title action in federal court. So sometimes it's hard to do a show cause or motion to vacate because the judge has already ruled against you, and you have to go back to that same judge and ask him to throw out 2 or 3 years of motion practice and put you back on the calendar. Even though I would say 60% of the times the judges will do that, but 40% or 20% of the time, they just don't want to be bothered. They want to get rid of you. They figure you haven't paid your mortgage, so let's just get rid of them. And the final thing, which I didn't list on here, which is not technically, it's not a way to save your house. It's a way to stall the foreclosure action, is bankruptcy. Please don't ever think you could save your house with bankruptcy. It does not happen. What it does, and we use it sometimes to stall the sale process to give us an opportunity to file a federal lawsuit. That is how you stop foreclosure. It's through a federal lawsuit. You can't stop it with a bankruptcy. So let's look at how to stop the foreclosure. So I told you, if you've already lost, if you didn't get in early enough and get the discovery victory, or you didn't win in settlement conference because you didn't have a big stick, you can always file an order to show cause. And this is an example, a recent example you could see here just back a couple months ago. We had a client that came to us. They were a couple days from being evicted from the sheriff. And we were able to get that action stayed, which is what you want, to give you another opportunity to go after that case. Now, once you have the show cause hearing, again, sometimes it's difficult to convince the judge to go ahead and put it back on the calendar. If he doesn't, that is not an issue for you because you can also file this action in federal court. And you can see here, this is one of our clients who filed it in federal court. They followed the same process. And one of the things that not only did they set up the initial scheduling order, but you can see here, the argument was so compelling, the judge ordered discovery. So at this point, it's an automatic win for us. The judge ordered discovery. So this client will be going back to court in January. And prior to that, we can file discovery. So in order for the defendants, which is the bank in this case, in order for them to have a choice, any type of hope of they can't win, but to have any hope in this case, they have to first get past our discovery. It'll never happen. So we know that this bank will settle very quickly because we're already at discovery. Sometimes when we get back on the calendar in the original case, we have to then motion the judge to compel discovery. And sometimes that is an uphill battle. But once we get discovery, the case is essentially over. One of the things I want you to be careful of, if you're talking to an attorney that's working to save your home, please ask them for their current track record on saving homes. They have to disclose this to you. What percentage of homes have you been able to save? So for us, it's 100%. So for some of these guys, it might be 5 or 10%. Or if they're reluctant to disclose that to you, that tells you all the things that you want to know. We stepped in and saved a house recently where the attorney was working with an investor, and what they would do is tell you to sell your home to the investor. Do a short sale. There's no way to save your home. Do a short sale. The reason they do a short sale is because they will convince the bank to sell it to a friend of theirs for a fraction of what it's worth. That way their friend picks up equity and they cut them into the equity. Meanwhile, you're out of your house. That is not a reasonable suggestion for somebody you're paying to save your house. Please don't short sell your house under the recommendation of someone you paid to save your house. It's a scam. One of the reasons that you lose your house to foreclosure, so many people do, is again because you don't understand what you're up against. I know that you haven't paid all your payments, you are late on payments, but what you don't understand is the federal government understood that you probably are at some point going to have problems making payments. So they put together programs to help you save your home from foreclosure. The government has spent trillions helping you to save your house. So I don't care how many payments you haven't paid. Some of our clients haven't paid their mortgage in 8 or 10 years. We were still able to save their home. Why is that? Because the government has already done the work for you. And to prove it to you, this is what I want you to do. Any mortgage company that's foreclosing on you, Google them. Are you kidding me? Any bank that you Google, look at this. Wells Fargo ordered to pay $3.7 billion for widespread mismanagement of auto loans and mortgages. Are you kidding me? Do you know in order to get fined $3.7 billion, you have to steal hundreds of billions of dollars? They are getting fined for mismanagement of mortgages and foreclosure fraud. So you should be saying, if I'm late on my payments, how are they guilty of foreclosure fraud? Google Bank of America, $60 billion in foreclosure fraud. Do you know how much fraud you have to commit to be fined $60 billion? Get out of here. So how do you find out? One of the tactics you want to use is first familiarize yourself with the foreclosure fraud process. Most foreclosure in this country is illegal and fraudulent. The reason they get away with it is because, again, you don't know the law or you went to the wrong person for help. So first thing I want you to do is go to this website, nationalmortgagesettlement.com. Nationalmortgagesettlement.com is a website put together by the federal government to explain to you their case against the mortgage industry. So back in 2011, the year 2010, every attorney general, 50 attorney generals got together and sued all of the biggest mortgage entities in the country for foreclosure fraud. Do you hear what I'm saying? All of the people were late on their mortgages. So how then can they commit foreclosure fraud? So that's why I want you to go to the website and see it for yourself. In that, you can see a copy of the summons and complaint filed by the attorney generals of this country. If you read it, then you understand, oh my goodness, the reason that I'm getting foreclosed on is not my fault. In their lawsuit, they outline how many billions of dollars the federal government gave the mortgage industry, TARP program, different programs where they paid the mortgage companies to offer you loan modification. That is not what they're doing because they're nice or they like you or they respect your business. They're doing it because they have to. Why are you getting turned down for loan modification? Your bank has been paid to give you loan modification. Are you kidding me? Your bank has already been paid 3 and 4 times. Read the complaint. The government gave them a TARP program, said, listen, please give all your mortgage customers loan modification. Here's a couple billion to make it easy for you to do that. They took that money and they still foreclosed. So the federal government offered them another program and gave them billions more. They did it 4 times in a row. And finally they said, hey, enough is enough. And they sued them for foreclosure fraud. So let me tell you this. You don't have to understand the entirety of what we're teaching here today. If you just go to this website, pull the complaint by the attorney generals, you can use that as a template to sue the mortgage industry yourself. It's impossible for you to lose because the government has already proved your case. If you already lost your house to foreclosure, you should be going to nationalmortgagesettlement.com, pull up that complaint and sue them for $1 million. It is impossible for you to lose. Statute of limitations, an excellent defense for foreclosure. You know, all written contracts are bounded by a state-run, what's called a debt filter. So if you've exceeded the time frame for statute of limitation, you can get the entire foreclosure just simply thrown out very easily. Let's talk now about additional ways to shut down foreclosure. So this is what I need you to do for me today. I need you to list out all of these and make sure you understand them. So let's say you have an attorney or somebody else helping you. One of the problems I have going behind attorneys, which frustrates me sometimes, and I'm going to say all the time, they understand standing and capacity. And most of the time, attorneys make an excellent argument for standing and capacity. Sometimes it's the judge that doesn't understand, and the judge rules against you. That's the judge's fault. And some judges are on the take. I hate to be the one to tell you, but some judges are being bought off by these industries. So it's possible that your attorney maybe meant well, but he just didn't have the resources. That's why I'm giving you the list. If you follow this list, it's impossible to lose your home to foreclosure. This is the recipe to save your home. If you lose one of these, you go right to the next one. And you keep filing motions indefinitely until you win. Let me explain one of our strategies. So if you feel like the judge is ruling against you or he ain't listening, change your strategy. He can't rule against everything because it's all based on law and it's already been pre-argued by all 50 attorney generals in the country. So you have to wear some of these judges down. Sometimes these judges get it right away. Sometimes the banks walk when they see where you're going, but you have to be relentless. You have to be the Terminator. No matter what happens, I'll be back. We do this with all of our clients. You know, sometimes they get discouraged early in, they lose round one and they get discouraged. And I have to encourage them, don't worry. We're going through all of these until we win. So the first one is standing in capacity. Make sure you understand what this is and what this means. Standing in capacity. So standing is your right to foreclose. In America, in order for them to foreclose, they have to prove that they own the mortgage and the note. And you think, oh, of course they can do that. That is difficult. If the mortgage was before 2010, it's almost impossible to do. They can't proof up their claim. You think it's easy? That is not true. And so you have to push the envelope. So most attorneys are reluctant to really push this and force them to prove it to you. But you have to challenge standing and capacity. So the standing means you have the legal right to initiate a foreclosure lawsuit, which means at the time of inception, you own the mortgage and the note. Mortgage and the note. Mortgage and the note. You have to have both. During every mortgage before 2010, there was a separation of the mortgage and the note. The notes were fractionalized and sold off, and then the mortgages, they sold those as well and made even more money off those. So they separated the two. So recombining them is extremely difficult. So what's funny, I was looking at a foreclosure case today, and the attorney was arguing, oh, we proved that we have standing because we attached a copy of the note. But they conveniently forgot to mention that they didn't attach a copy of the mortgage because they don't have possession of it. But if they argue hard enough wrong stuff and your attorney skips this very valuable stage, then the judge, because you didn't deny it, he will agree with them and you will lose. I need you to have standing, which means you have both the mortgage and the note. Once you have standing, I need to know, and this is crazy. This is going to scare people once you understand this, capacity. They have to have the capacity to sue. Capacity refers to a party's legal ability to participate in a lawsuit. That sounds crazy, right? Let me explain to you what that means and why we never lose. Because most entities that are suing you don't have the capacity to sue. So let me give you an example. In order to sue in the state of New York for any debt, you have to be listed with the Secretary of State. In order to, additionally in New York and some states, you have to be listed as a debt collector. So as soon as you're not listed as a debt collector in that state, or you're not listed with the Secretary of State, you are automatically prohibited from foreclosing. Let me give you an example of that, which we destroy people with. Let me give you an example. So recently, where we overturned a couple foreclosure, they were against U.S. Bank as trustee for, you've seen it, for blah, 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 right? Because you're not arguing, or your attorney's not arguing capacity, I'm going to show you one of the greatest cases that we won, and it was won solely on the capacity issue. But you say U.S. Bank as trustee is suing you, so everybody knows who U.S. Bank is. Of course, U.S. Bank has capacity. They're a national association. They're a bank. Wrong. You're not being sued by U.S. Bank. If you were, they would say U.S. Bank. They don't say U.S. Bank. They say U.S. Bank as trustee for blah, 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 blah. That is a separate entity in and of itself, and it is a separate corporation. That corporation has to have the capacity to sue, and they never do. They have to be listed with the Secretary of State as U.S. Bank trustee, blah, 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 blah. They can't be. U.S. Bank N.A. is a different corporation. Do you understand? U.S. Bank is completely different. Unless you're telling me that U.S. Bank owns the debt, that I can understand. If you are, and you have to raise this argument just like I'm telling you. If U.S. Bank is who I'm going up against, simply change the caption and say U.S. Bank. Now I know how to attack this debt, because now U.S. Bank has to proof up that they own the debt, which we know they can't do. They use a fake corporate entity because they know you're not going to challenge capacity. Your attorney's not going to challenge capacity. Get out of here. So they use a fake entity because you don't challenge capacity. Please, let's keep going. Here's an example. Okay, this is it. So this was what I consider our greatest victory. This client owns a penthouse in Manhattan, worth I think 10 or 20 million bucks. They had a very small mortgage, maybe 3 or 4 million, which they defaulted on, and the house was up for foreclosure. Now, this was their long-term family house, which he had inherited, and now it's going up for sale. So this client automatically, he lives in Manhattan in a penthouse. So the first thing he did, he went to 2 Wall Street law firms to save his house. The first law firm lost the house, told him he had to get out. He went to a second law firm. Each one he paid close to 100 grand to 200 G's. Both of them lost. The second law firm said, you got 2 weeks to get out of your house. We lost. So, man, this is why people hire either terrible lawyers or they don't hire anybody, because they're paranoid that you're going to pay somebody $250,000 to save your house and they're going to lose because there's no guarantee, right? So you can see here, it says the defendant now moves for order pursuant to CPLR, granting renewal of his motion to vacate. So he's already lost through another law firm came in did a motion to vacate, which we talked about earlier, and they lost, which I told you that happens. This is a Wall Street law firm, and they lost the motion to vacate. They lost it. So now I'm going back to the same judge and saying, I know 2 Wall Street law firms argued this case. Both of them, you denied their motion and threw it out. But now I'm coming back, and we did this case pro se. So the client came back without an attorney. We just had one of our legal department, one of our attorneys prepared the paperwork based on my strategy. And so now he's going back without an attorney, facing the same judge after losing with 2 Wall Street law firms. So you see, now he's asking to grant a renewal of his motion, originally filed October 1st and previously denied by the court on October the 10th. The client was paranoid and crazy, but he was referred to me by a good friend of his who said, trust Dr. Grayson, he has never lost a house. This guy was like, I had 2 Wall Street, the best law firms in the country, and they lost. What could Dr. Grayson do? I'm going to show you what Dr. Grayson did. So let's see what the judge ordered on this case, which of course is a public record. Ordered that, ordered the defendant's motion for leave to renew and is granted to the extent that the October 11, 2012 order is vacated. So we were successful. Now, depending on the case, and we didn't really talk about this, the motion to vacate, you can do multiple motion orders to vacate. You can do multiple. And sometimes, depending on where we are in the case, I might do multiple. But if I think the judge is very biased and it's going to be a waste of time, we don't. But if the judge seems reasonable and not like he's on the take, then we will keep doing it. Because, and this is a case where they've already done multiple motion to vacate. I'm coming in with a new one, right? But it was very successful. You see here, the motion to vacate was ordered, but let's keep going because there's more. It is further ordered, excuse me, that the plaintiff's amended complaint is dismissed in its entirety. Because I'm going behind 2 Wall Street law firms, I couldn't mess around. Sometimes I do stuff to feel out the judge and see if the plaintiff will resolve amiably. Okay? I want to see if the plaintiff is going to wake up and give you low mod. And that's quick and painless. But in this case, I couldn't. So everything that I'm mapping out to you today, I put it in a 100-page document. This document was crazy. Even if you threw out 10 of the things, there was 100 things that made it impossible for the judge to throw them all out. If the judge just ruled in favor of one of those things, he had to throw the case out, which is what happened. And in addition to that, you can see here it's ordered that the plaintiff their cross motion for sanctions is denied. This attorney, this law firm was very unhappy with our motion. So what they did was to scare the client. They filed for sanctions. They asked for $50,000 in sanctions because they called this a frivolous lawsuit. They said, Your Honor, he's hired 2 Wall Street law firms, and now he's coming up without no attorney and filed this lengthy motion. It's frivolous. We want damages. We want sanctions for $50,000. Can I tell you something? The client was very unhappy with me. The client was calling. He was kind of nice, but he was kind of not nice. Because he's like, in addition to losing my house, now I got to come up with $50,000 to pay sanctions. But I said, listen, man, just relax. Stay the course. Most of my time dealing with clients is telling them to relax and stay the course because we always have an exit strategy. But in this case, as you could see, it turned out in the client's favor. Champerty is, again, another crazy thing. I want you to read this for yourself. Don't take my word for it or ask your attorney about it. Champerty prohibits the purchase of securities or other financial instruments for the sole purpose of litigation. Guess what a mortgage is and the promissory note is? It is a financial instrument. So if you purchase a financial instrument like a mortgage, and then you sue me for foreclosure, that is champerty, people. How are you losing your house to foreclosure? You don't even know the name of the bank that's suing you. You're being sued by U.S. Bank trustee for secure back security number 23. Who the heck is that? If you don't know them, it means they did not accelerate the mortgage. The law says before they foreclose, they got to accelerate. Accelerate means you give me at least 5 opportunities to pay. You have to send me a notice of default, a notice of default. You have to give me a pre-notice before foreclosure. You have 5 notifications. If I don't know who you are, then of course you didn't accelerate champerty. Of course, we got hundreds of examples of that. QWR. Oh my goodness, is this thing powerful. QWR is a qualified written request. RESPA, write that down and please research this for yourself. Real Estate Settlements Procedures Act says that you have the ability to ask your mortgage company anything about your mortgage. And they have to respond within 30 days. If they don't, you can sue them for damages. And that means the value of your home, which means your house is free, crazy people. So everybody knows what a QWR is. If you talk to somebody, they say, oh, you talk to your attorney. He's like, QWR, oh, that ain't gonna work. I don't know why Doc telling you about a QWR. I know what a QWR. Let me show you what I'm talking about. I went to Google and I said, give me a sample of a QWR. I have people send me, if their lawyer say, oh, we did a QWR, send it to me. Let me see their QWR. And this is what the QWR normally looks like. It says, send me a complete payment history, which lists the date and amount of all the payments. Wrong. Everybody can do that. What I asked for, write this down, life of the loan transaction report. That is what you should be asking for, not a complete payment history. They're going to send you what the last bank sent them was the last couple of years of your non-payment. That is easy to provide. Are you kidding me? I want a life of the loan transaction report. That is from inception. And I have to use the exact terminology, life of the loan transaction report, because that is a legal construct. Let me tell you what you will find. Now, it's not often that you get those. Most banks will run and offer you loan modification right away. Okay? A few of them hang in to see what you're about, and they will send you the life of the loan transaction report. I dare you to give it to me. I dare you to read it. I dare you to ask for it, because what you will see on it, they got all of these columns. Now, I'm going to tell you, this document's probably 100 pages long, and they know people are lazy. Even your attorney, they ain't going to read all of that, and they don't know what they're reading. They're not mathematicians or accountants. They just going to look at it and say, oh, I got it. Wrong. When I get it, I'm looking for one thing. I'm looking for the column that says, and write this down, unapplied funds account. Unapplied funds account. You better not have a single dollar in the unapplied funds account. Do you know what the unapplied funds account? Let me tell you this scam that they ran on you. And again, it goes back to you figuring out, why is the government saying that mortgage companies commit foreclosure fraud when I'm late on my payment? Why are they saying you're still committing fraud? Unapplied funds account. So what was happening, mortgage companies knew that they were buying these mortgages just to sell them later. So when you were making payments, they put them in an accounting entry called unapplied funds account. And then when they sold the mortgage, they forgot to credit it against your principal. That's why I talked to a client the other day. They took out a mortgage for like $350,000. They said they owe $1 million. Man, get out of here. That's why you owe more now than what it was worth when you took it out. Get out of here, people. My QWR is scary. I'm asking them things like this. Who did you sell the mortgage to, and how much money did you make off of it? Because legally, if you fractionalize and securitize it, which I know you did, you can't lie and say that you didn't. I should participate in that, or should be credited against my mortgage. How much did you sell it for? When you sold it to investors, what did they pay you? That is information about my mortgage, and by law, you have to tell me. Guess what? I ain't never met a mortgage company to answer that question. But guess what? By law, they have to answer, or they got to give me loan mod. The reason you're not getting loan mod is because you don't carry a big stick. The reason you're losing foreclosure is because your attorney didn't do this in discovery. Once you apply for loan modification, the mortgage company has to shut down the foreclosure. If they don't, it is called dual tracking. Guess how often I can apply for loan modification? Even if I've been turned down, guess how many times I can apply for loan modification? Indefinitely, people. If I apply for loan modification, they have to shut down the foreclosure till they decision the loan mod. You get where I'm going with that? If you have questions, ask. When you do the QWR the right way, you get a letter like this. Now, this client was cracking up because she tried for loan modification about 10 times. She hired all these agencies, loan modification agencies, and they just missed it right away and went to foreclosure. I QWR'd them only, and they sent her this letter. It says, there are no closing costs, no fees, no meetings or paperwork. All you have to do is sign and return the agreement and make a payment the next month. Consideration for mortgages after 2010 or before 2010, I would use this argument a lot, but it's so easy now with the attorney generals making the case for you. I don't even need this. I don't even pull this out. This is like my emergency go-to last hope argument. And I haven't used this in years. because, we just have been very fortunate. But if all else failed, I'm going to go to consideration. So, but I need you to understand what it is. In a contract, consideration refers to the exchange of something of value between the parties involved, meaning each person gives something in return for receiving something else, making the contract legally binding. So if you don't give consideration, the contract is not legally binding. Let me tell you how many, I can't even tell you how many foreclosures we shut down just on consideration. Let me tell you what will happen. When you are doing an audit of the foreclosure documents, look at the title documents. In order, on the title, it tells you what they paid for the mortgage, right? On most of these, they got them from a company called MERS, and MERS assigned it to them for $50. So they got the mortgage for $50. Then now they're turning around and suing you for $500,000. Are you insane? In order to sue me, you have to have consideration. So if you paid less than $250,000 for this and you're trying to get $500,000, you are in trouble if you come up against one of my clients. Don't show me no title where you paid $50 for something. Now you asking for $500,000. Impossible. Let me give you a case that you can research. It's called Credit River, if you Google that. So in this case, the client bases defense on the argument, and this one is more aggressive. That's why I don't really want to go into it unless you really want to know. But this client used an argument that we use routinely, and so it's very powerful, but it's very complicated. So he said that the bank actually didn't loan him any money. They simply created a credit on the books. So if you understand the banking system in America, banks do not lend you any money, people. I hope you guys know that. The promissory note creates a debt with the Federal Reserve. The Federal Reserve loans the money. Technically, banks are just brokers. So therefore, in terms of foreclosure, a bank doesn't have the capacity to foreclose because they didn't loan you any money. Look at this case and it'll prove it to you. Banks don't loan no money. How can a bank have the kind of money it takes to do millions of mortgages? Where would they get that? That would be trillions and trillions of dollars. You know, no bank has that kind of money, people. Banks don't loan money. You loan it to yourself through the Federal Reserve System. They're a broker. And I'm not saying they're not a valuable member of the chain because they are our buffer between you and the Federal Reserve. But I'm saying legally, they don't have the capacity to sue for foreclosure. Any mortgage before 2010 was used. They used a system called Mortgage Electronic Registration System. Most states have ruled that if MERS is involved, the foreclosure is invalid. Again, make sure your people are challenging that. That's how you can, as you can see here, we get letters like this. We're canceling the remaining amount you owe. You see here, this client owed $415,000. They walked from the mortgage. What an involuntary bankruptcy is, if you owe somebody else some money, they can file an involuntary bankruptcy against you and leverage your house. So if they have your house in bankruptcy, you can't be foreclosed upon. Do you hear what I'm saying? If somebody else uses a bankruptcy, it's called involuntary because you are not a party to it. You're not filing bankruptcy. They filed an involuntary and listed your property as collateral. So it is impossible to foreclose on that asset. Yeah. The only way they could possibly foreclose on it is if they paid off the bankruptcy entity. Okay, make sure this is how you fight that zombie debt foreclosure, the Mortgage Forgiveness Debt Relief Act. And so it cancels all debt that's forgiven through the foreclosure process. So please write down that act. And you can also use that to clean these things off your credit. If you've already lost your house to foreclosure, you want to use this act to eliminate the debt and then remove it from your credit.